What's up? Hey, I'm Shiva and this is episode number 3 of this Alumni ASSOciation episode of Boot to Moot. My buddy Aditya would have probably told you before about the petitioner side. Now it's my chance. I'm going to do the respondent side. I'm going to keep it pretty brief with just the main points of this particular discussion. Let's not forget that it is a moot court, and before we start anything, I would just like to establish that before we start anything, it is a moot court. And the main aspect or main point which you want in a moot court is to impress the judge. Never should you go for a moot court wanting the case to go in your favor or not. It's about impressing the judges with your ability to speak, with your ability to put points forward, and your memo does hold some water, but don't worry if your memo isn't too good, you can always make up if you speak well. Setting that aside, let's get down to the main point over here. That is this particular case, which is Shivaji versus State of Arunachala. Your petitioner is obviously Shivaji and your respondent is obviously the State of Arunachala. I will safely assume you know all the facts of the case, so I will not even bother to venture over there, because if you don't know the facts of the case, then you better start reading. Okay. For my convenience sake, I do have a piece of paper here with around 3 or 4 points, which I'm looking at right now. So you will have to forgive me. I would bend down and look at this. There are 3 main issues that I would like to put forward in this particular venture of trying to help you in this moot court. The first issue which I would like to put forward is the question of the SLP and its validity. The next one would be the necessity of upholding the High Court's decision, and the third one would be the whole phenomena of euthanasia and how is it relevant to this case. I'm going to keep it very brief right now. I will start with the question of the SLP and its validity. As my buddy Aditya would have already told you, there is a 90-day time limit for this SLP. Now, as a respondent, you would like to emphasize on the fact that this SLP is not valid. On what basis is this SLP valid? Well, possibly the petitioner could come forward and under the Limitations Act, section number 5, give a valid reason or consideration for why there was a delay in the submission of the SLP. If the SLP has, is of dire circumstance, or there was some unforeseen events that led to the delay of the SLP, the court takes that into consideration. Now, as the respondent, you want to establish that whatever the petitioner puts forward was not a dire circumstance or something that did not warrant this delay. Although as shallow as this may sound, for establishing a case, not morally, for establishing a case on whether the SLP should be valid, it is but a point, and it's subject to your analysis how much emphasis you want to put on this. In fact, while discussion with Aditya on this particular topic, we came to the conclusion that although there is a certain amount of importance that should be given to this particular aspect of the time limit with relationship to the SLP, it should not be the core essence of what you are arguing. It should be used as a point of to establish the fact that the SLP was not filed within the prescribed time limit, but overemphasis on this would probably distract you from the more major concerns in this case. To be honest, the judges in the moot court would probably listen to your point, but still ask you to continue, saying that the petition is maintainable, for the simple reason that they just want to hear your other points. It's a moot court, so they will not dismiss a petition on the basis of its non-maintainability, because then the judges don't get an opportunity to listen to your other issues. So, talking about other issues, the next issue, which is of core essence, would probably be the necessity of upholding the High Court's decision to not squash the FIR. So the High Court has basically rejected the petition that was put forward by Ms. Shivaji, who is the wife of Mr. Shivaji. She is the wife of Shivaji. And basically this petition was to squash the FIR. The High Court rejected it. On the basis of this, SLP has been filed to the Supreme Court, and in consideration for that, there has been 2 aspects that has been pleaded. One aspect is the aspect of squashing the FIR because of reasons which I shall come to later. And the second aspect is the question of a writ petition that is basically to, ask the Supreme Court to interpret Article 21 in a method that is favorable for the inclusion of the concept of right to death in right of life. Wow, this is getting a little heavy over here, so I should just try and make that a little easier. The simple aspect here is that there is an individual called Mr. Shivaji, as you would know from the case, and he is currently in an atrocious state of health. And he has attempted to commit suicide. As a respondent, you want to emphasize this point. The man, irrespective of the facts and circumstances he will, whether he be in any kind of state of health, has attempted to commit suicide. Attempt to commit suicide is a punishable offence under the Indian Penal Code, Section 309. That's where its relevancy comes. So now you have to look at, as a respondent, you have to look at this without any inclinations towards the emotional side or inclinations towards humanitarian side as such. You are not humanitarian. Oh, sorry, that's a mistake. Not humanitarian side. As in, you got to look at the core essence of the thing, the act and its consequences. What is the act over here? The act is an attempt to suicide. The consequences is penal consequences. Now, let us understand, as a respondent, it is important in your case to understand what would have been the possible reasons why the HC would have refused to squash the FIR. See, as established by the court of law today, attempt to suicide is a punishable offence. The reason for the FIR, as would have been probably, if you had, you obviously probably have seen the petitioner's video. If you haven't, please do. There was a mention of motive and intention which Aditya had said. This concept can also be used when you're talking about the respondents. What is the intention of the FIR over here? The intention of the FIR is a procedural factor in which the police accumulate information, and then after filing a particular charge sheet or as such, what is there, they give it forward to a magistrate. What is the motive of the FIR over here? The motive of the FIR, what I believe and what you should believe if you are the counsel for the respondent, is that you are trying to prevent a bad precedent or setting a bad example that is against the penal law of the country and public policy. Why is it against public policy is now the question. Here comes the meat of our whole discussion. The reason what you will have to tell the Supreme Court or the Honourable Bench in this case is that, and to uphold the High Court's decision, is that the fact that if you were to warrant the concept of a person taking his own life, it would set a large number of problems and misuse of the particular concept. Chiefly, what is the only authority in the land that can take life? It's the judicial system, the judiciary. There is no other competent source or authority that is allowed to take life legally. So, what are you basically doing if you are trying to encourage or put a decision in which a person who's terminally ill, forget about his circumstances, as a respondent you have to be completely sure on the point that you are not going to cave into the aspect that this particular person was terminally ill or was suffering of some particular problem. The petitioner in this particular case, irrespective of what his health circumstances, committed a penal offence. Now the argument that's going to be put forward to you is that the individual in this particular case was in dire states of health. Yes, there is no denying that the person was terminally ill, had bone cancer, multiple organ failure, suffering financially, burdened physically, mentally. The list goes on. But how does this change the fact that the act of the petitioner was a penal offence? You got to be pretty straightforward over here. The FIR is a basic legal formality. The FIR intends to book a particular person on a particular aspect of book a particular person for his crime rather than looking into the aspects of what the crime is. That is subject to judiciary, and that's why this particular case has come forward. So I would not like to re-emphasize on what I have said. I just like to keep it as far as this issue, which is the necessity of asking the Supreme Court to uphold the High Court's decision with regard to squashing the petition, or rather not squashing the petition, that the FIR basically is a procedural factor that was taken into consideration, taken suo moto by the jurisdictional police to file an incident of the petitioner attempting to commit suicide, which is a penal offence by section 309. The rest, subject of interpretation, is up to you and up to the convenience of your time while telling the judge and how much more you can emphasize on this. Now the second part of the issue, or rather which I would like to put as my third issue, is the phenomena of euthanasia. All set aside this particular issue